case that involved an Alabama Supreme Court state justice who sat on a case that involved an insurance issue. And it turned out he had a different case that was pending in the Court of Appeals at the same time. And after that came out, the insurance company appealed to the U.S. Supreme Court, which reversed the decision as a violation of due process for the judge to sit in a case in which he has, it would benefit him in a different case, but it was the same issue. So to me, it's the same thing. Now I want to respond also to this issue about all these orders that Justice Sanders says that he was in agreement on. I looked at all of the decisions, disciplinary decisions over your 15 years in the court, not just the last 2 years. But I want to point something out. It's an advance sheet. We all know that. I looked at the opinions in the advance sheets and in the published cases. That's what I looked at to see. Now, this particular advance sheet, April 6th, has 100 pages of opinions, 5 opinions. But if you look in the back, it has 8 pages of denials of petitions for review. I don't think that's particularly significant to figuring out statistics. And it has 1 page of orders on disciplinary cases. Justice Sanders' name is not on any of these. He may have agreed with what the court did, but there's no opinion here. There's no opinion because the court didn't do anything about it because the lawyer never appealed the sanction in these cases. These are non-appealed cases that you're talking about. Nobody wrote an opinion on them because there was no appeal on those cases.
Can I respond to that last?
Very, very brief.
Well, that's not the way Mr. Wiggins explained it in the newspaper. He said, voted 91% of the time for lesser sanction than lawyer discipline cases. The only way a lawyer can get suspended or disbarred is by order of the Washington State Supreme Court. He didn't make any distinction there between orders or narrative opinions. He didn't make any distinction between divided courts and undivided courts. And I don't think that any way you look at it, it would be 91%. Or if there's some nuanced way he can get there, I think he has an obligation to explain it clearly so that people aren't misled about my record.
Okay, Maria, did you have a question?
Yeah, I do, and I'm going to preface it with just a brief comment. I mean, I have to say that, in a hotly contested election, obviously there's going to be personal attacks. But, I think myself and most of us here have a great deal of respect for Justice Sanders and a great deal of respect for Charlie Wiggins and the appellate lawyer. And so it's personally a little uncomfortable for me to see the two of you launching personal attacks. So for at least this round, I'd like to sort of change the tone of the discussion, and I'll direct this question to Charlie, which is, first, Charlie, I'd like to hear from you, if you are elected, how you would see your role and your impact on the court given its current composition. And in response to that, Justice Sanders, I would be interested in your comments as to how you see your own role and your impact on the current court.
I think that my role, the way I view myself and the way I think I would function on the court is much more as a moderate, as someone who tries to build consensus, as someone who tries to reach a common ground and try and stake out a common ground. That is not to say that I would never dissent, even on the Court of Appeals, which has very, very few dissents. I wrote probably more dissents than most of them in a year, which was probably 3 or 4 dissents, because on the Court of Appeals you don't have the luxury of dissenting. That's a high-volume court. And so that court strives to reach a common ground, and that's the way I would see the role. That's not to say that anyone compromises their principles. It is to say that you strive to find a way to resolve a case that more people can agree on. I think that's helpful to the practice in bar. I think it's helpful to judges. It's helpful to the public to have clear cases, less fractured cases. That's the way I would see my role. Certainly that's not to say that one gives up your view or just goes along to get along. That's not what I'm saying at all. I would say that, but I do think that one of the aspects of a collegial court is that the court tries to reach a collegial, collective decision.
Well, I recall that our Supreme Court and the other Supreme Courts of the Northwest used to have a summer outing every summer And we were at Glacier National Park, and I was taking a hike with a Supreme Court Justice from Oregon. And I asked him, how many of your cases are unanimous? And he says, well, down in Oregon, we think with one mind about 95% are unanimous. And he said, how about Washington? I said, well, in Washington, we all think for ourselves, and it's about 50%. So I think you have a 9-member court. And I try to make my contribution. I look at the world a little differently than some of my colleagues, and I try to speak up and defend my point of view, and I'm not afraid to write an opinion that states that. Listening to Charlie reminds me of Justice Chambers when he first came on the court, because he was saying, you know, what we need to do is build consensus on the court, and let's try to all get together on these cases. And that lasted for about 3 months, and then he threw up his hands, and he was doing his share of dissents at that point too. So I think that's healthy. I had a lot of appeals, and it was always disconcerting to me when, especially, it was always disconcerting if I lost, especially unanimously. If there was a divided opinion, at least I knew that these guys were thinking, and that the debate did not end at the podium, but it continued on in the conference room and thereafter. And there's been many cases where I've filed a dissenting opinion, which ultimately became a majority, and vice versa. And it forces, and when people do that, it forces the other judges to think and write better opinions. So, but I think my contribution to the court has been a love of liberty, a love of civil liberties, to try to fulfill the constitutional mandate, and that's what I had hoped to accomplish on the court. And I've been the kind of judge that I wanted to be, and I haven't gone along to get along. Sometimes it's hopeless to get a majority, but it's never hopeless to tell the truth about a legal issue or a case. So I've had a lot of fun on the state Supreme Court, and I'd like to keep my government job. Charlie.
Anybody on the phone have a question for Justice Sanders? Okay. Art Grant.
Thank you. A quick comment and then a question. It's been my experience that you can't quote a newspaper because you can't control what they print. And so I don't believe you can say that Justice Wiggins, or Attorney Wiggins, in any way could control what was printed. So I don't believe that that's a quotable source. And my question is, and I have a little bit of experience in this area since my spouse is a judge, there are a lot of things that judges can't do. And they can't do it for a number of reasons. Appearance of impropriety, the risk of getting involved in a situation or relationship that may be improper or inadequate. And so it concerns me when you, as far as I can see, you went off on a lark with this public disclosure issue, when it would put you in a position that would raise concerns about your ability to do your job. So my question is do you accept the fact that there are things that judicial officers cannot do?
The question, just so those on the phone can hear it, is Justice Sanders comfortable with the fact that there are certain things judges cannot do, whether for appearances of impropriety, etc.?
It comes with the territory.
Well, yes. There's a code of judicial conduct that tells you what you can and can't do. In my tour of the Special Commitment Center, judges are encouraged to take prison tours because you get continuing judicial education for it, credits for it. And the Commission on Judicial Conduct has issued press releases how they say that they want to encourage judges to take prison tours. one thing that the Code of Judicial Conduct prohibits is ex parte contact, improper ex parte contact. So then I took the